What should you do following a DUI arrest? I believe the first thing that a person should do after they get released from being incarcerated following a DUI arrest is obviously get themselves home, get themselves showered, get themselves fed, and get themselves ready to address the stress and anxiety that's going to follow for the next few months. A DUI is unlike any other criminal charge, whereas the arrest itself automatically has ramifications for a person's driver's license. A court does not have to be involved in regards to suspending a driver's license following a DUI arrest. Immediately following a DUI arrest, the DMV is going to likely suspend a person's driver's license for one of two reasons. First being that person provided a breath sample and that sample was above a 0.08, or that person refused to provide a breath, urine, or blood sample, and therefore their license will be suspended for the refusal. Now, what do you do about the driver's license? There are some options. If this is the first DUI arrest or first-time alcohol-related arrest, the person is eligible for a hardship license in the state of Florida. This only applies to a person who has no prior DUI charges. So if a person is arrested, refuses the breath test, or provides a breath sample over a 0.08, they have to make an election within the first 10 days following that arrest as to whether or not they're going to seek a hardship license from the DHSMV. Now, there's only 8 Bureau of Administrative Reviews or hardship license offices in the entire state at this point. If a person decides that they want to elect to get a hardship license and not challenge the suspension, they have to enroll in DUI school and provide a form to the Bureau of Administrative Review office and waive their right to a formal hearing. Any person arrested or charged with a DUI has the right to a formal administrative review hearing to challenge the suspension, whether it's a refusal or a breath sample. That hearing is meant to litigate whether or not law enforcement essentially had a basis to arrest a person for a DUI and whether or not that person did in fact provide a breath sample that was either above a 0.08 or refused to provide the sample that was requested. Most persons choose to elect to get the hardship license. It's a guarantee, and in Florida, where public transportation is lacking, most people can't afford to be without a driver's license for any period of time. If you elect to have administrative review hearing and you prevail, your license is reinstated. If the DHSMV sustains the suspension, there's a mandatory 30 days of no driving if it's a breath sample case, if it's a 0.08 or higher, and a mandatory 90 days of no driving if it's a refusal. The analysis I always start with when advising clients whether or not they should have an administrative review hearing or whether they should waive that right and obtain a hardship license is whether or not they can afford to be without a driver's license for 30 or 90 days. Can they afford to not drive a car during that time period? If the answer to that is yes, then I recommend pursuing the hearing. If the answer to that is no, I cannot, I have children, I have a family, I have work, I have other responsibilities, I cannot be without a license, then the answer is no, and I generally advise clients to pursue the hardship options. I personally like to review a police report and a probable cause affidavit before making any recommendation in regards to the hardship hearing. I always advise a client that it's best to have an attorney review records and advise what they see on those records as to the strengths and weaknesses of that hearing. Again, for some people, though, they cannot take the risk.